First, I want to give kudos to Russ for incorporating Grumpy Cat into a presentation on disability discrimination. I didn't think it could be done. Maybe it's Friday the 13th working for you. Yeah, quite the challenge. So the topic of my seminar is Too Poor to Pay, an employer's financial circumstances leads to a reduced notice period. You might be in a state of shock at the moment. Some of you in this room have experience with negotiating severances with employees that were let go, unfortunately due to financial reasons or financial difficulties. During these severance negotiations with the departing employee, and maybe with his or her lawyer, you may have thought to yourself, what about us as the employer? We're struggling. What about what we're going through? This wasn't an easy decision, you know. It may not have been animated, but internally, you may have had these kinds of thoughts. There may be a glimmer of hope that the courts in Ontario may be willing to look at the employer's financial circumstances in calculating a reasonable notice period for a terminated employee, at least in some circumstances. In a recent decision from the Ontario Superior Court of Justice out of Owen Sound, the court considered not just the employee's employment characteristics and circumstances, but those of the employer as well. You're likely generally aware that when a court assesses a reasonable notice period, it looks at factors such as age, position, length of service, availability of similar work, etc. However, in Gristy versus M. Key Schaub Climate Care Inc., the case out of Owen Sound, a different approach was taken. Now, Mr. Gristy, the plaintiff in that case, was 52 years old at the time of termination. He had just shy of 12 years of employment as a gas technician repairing and servicing furnaces. He earned, on average, about $55,000 per year. Mr. Gristy had a long-standing arrangement with the employer that he would only work when there was work available. So I'll call it sort of a non-traditional employment relationship in that there wasn't a set 40 hours per week or part-time hours per week that this individual was working. It was on an as-needed basis, which definitely sets this case apart. Now, Mr. Gristy, along with 8 others, were terminated in 2011. And at the time of termination, unfortunately, business was slow and the company was suffering due to poor economic climate. Mr. Gristy was offered 16 weeks of pay in lieu and notice, which was above the statutory minimum. However, he rejected and brought a wrongful dismissal action, seeking 18 months. At trial, he reduced his ask to 12 months of notice, bringing it down to more of a reasonable amount in his eyes, which the court appreciated. Now, during the trial, the employer argued, and this is novel, had Mr. Gristy worked during the reasonable notice period, so had he been provided working notice of termination as opposed to pay in lieu, his earning power would have been reduced due to the slowdown in business. Instead of working, say, 35 to 40 hours per week, he would have worked much less. The employer asked the court to take into account the economic factors, including the market and financial health of the company, at the time of the plaintiff's termination in determining what his reasonable notice period should be. The court, surprisingly, agreed and ruled that Mr. Gristy was entitled to damages based on the salary he would have earned had he worked during the notice period. The court found that he would have worked somewhere in the range of less than 34 hours per week. However, the judge stated, how much less? I don't know. This is interesting in that the judge didn't require any kind of calculation, exact or specific calculation of the projected hours this employee would have worked. It accepted an approximation. Ultimately, as a result of the employer's poor financial health, the court reduced the notice period from 12 months, which it found appropriate, to 8 months. So it cut the notice period by a third. Now, what sets this case apart? This case could signify a welcome shift in the right direction for employers, particularly for employers who employ individuals who work on an as-needed basis, such as Mr. Gristy. A few takeaways on this, if an employer is willing to make such an argument. The employer would need to be in a position to produce specifically confidential financial information. That could be a factor in terms of demonstrating to the court that there are such hard times being experienced and that the reduction is necessary. Now, right now, the applicability of this case, Gristy, seems to be limited to employers that hire individuals to work on an as-needed basis. However, we will wait and see how similar arguments are received by the courts and whether other judges will follow suit in terms of looking at an employer's circumstances when deciding what the reasonable notice period should be of a departing employee. Thank you.